subject to costing and other factors being taken into account, and reverting to Cabinet once those details were available.
Yes, we'll get there in due course, Minister. If you would deal with the evidence you've put forward at paragraph 43, please.
Well, that's what I have just described, and it indicates here energy approach to National Treasury for input on this. I think the main point here is firstly the point the Chair referred to earlier on, or you might have, I forget, about the so-called deal or agreement signed with Russia, which is the first part of 43. And the second part is how awareness of this agreement appeared on the screen. And it appeared because the Department of Energy approached Treasury to comment on a tax incentive which the Russians required as part of this deal. And the tax expertise obviously lay within lies in the National Treasury in this particular regard. And that's when the officials became aware of that fact. And secondly, as the statement says, assess the implications under the Public Finance Management Act. So that again would follow whether you're following process properly or not. And officials within Treasury raised concerns with the draft agreement and its clear objective of creating firm fiscal commitments to Russia. So, I mean, we signed many memoranda of understanding with different countries, Chair, on different matters or between different agencies. But a memorandum of understanding is precisely that. It cannot constitute a firm fiscal commitment. And this is where the timing and the scaling and so on of this project becomes quite material. So I think the key point being made in 43 is how did the Treasury colleagues become aware that there was this agreement? And that's what it actually describes.
Then if you could move to paragraph 44, please, where you deal with the attitude of the National Treasury to the proposals of the Department of Energy and the undertaking to prepare a feasibility study or a commentary on Energy's feasibility study.
I think you've described it. So I accept your description that the Treasury objected to the crafting within the agreement on the one hand, and on the other hand undertook to prepare commentary on the feasibility study and financing studies that the Energy Department had actually done.
Did National Treasury follow up on that undertaking?
So that would have happened post 2014, but before the 9th of December 2015.
And you refer to a continual interaction between Treasury and the Department of Energy in regard to costing and financial aspects of
That's what I'm advised by the officials.
Build program.
That's what I'm advised by the officials.
Then what happened in June 2014 to the NNCC?
So look, this is where the Chair's point comes in, that in June 2014, that is after the elections, the NNCC was converted into the Energy Security Cabinet Subcommittee and was chaired from then on by the former President in place of the Deputy President, Mr. Motlanthe. So earlier references might have to be corrected. And the ESCS, as it is now called, was responsible for oversight, coordination and direction of activities for the entire energy sector, but clearly the focus was on the nuclear part of it at that point in time. And we then list under 45 the ministers who constituted that committee.
And they were, would you mention their
Minister
names?
of Energy, Minister of, well, Ms. Jumat Peterson, Ms. Lynn Brown, Ms. Maite Nkwane Mashabane, Mr. David Moshlobo, Mr. Nene, Mr. Dr. Davies, Mr. Patel, Advocate Ramatlodi, and Ms. Mapisa Ngakula.
You invite the Commission at paragraph 46 to investigate the rationale for these changes. I understand there were at least two changes, the one in the scope of the committee and two, the membership of the committee. Do you have any particular issue in mind and that suggestion to the Commission?
And three, the chair of the committee.
Chair of the Commission.
As well. So,
I understand.
well, when I think I've heard I've heard anecdotally, Chair, that this was quite material to the eventual outcome of this process, culminating in the memorandum to the Cabinet on the 9th of December 2015 from the officials of the Treasury, and Mr. Nene would be able to add more light to this as well. But my perception from the outside was that this committee was constituted in a way to ensure that a majority decision in favor of whatever proposal was put forward would not be too difficult to obtain.
Well, I was about to ask you whether, to your knowledge, there was any significant reason for the change in terms of who was chairing it. There was a change of, I don't know if chairmanship is the right word. There was a change in terms of who was the chair. To your knowledge, do you know whether there was any specific reason for that particular change?
I can only surmise that a new sense of urgency was entering the equation.
Was it a cabinet subcommittee? The Energy Security Cabinet Subcommittee is, I understand, one of many subcommittees that would have operated within the jurisdiction of Cabinet. Am I correct?
Yes, they're called by different names, Chair. So you can have interministerial committees, you can have task teams, which we'll come to, or you could have structures of this sort as well.
And I've been requested to ask you, do you know how many Cabinet subcommittees or committees the former President chaired, or as general practice a President would chair, generally speaking?
Not too frequently is all I can say, but I'm sure the Presidency can assist you with that.
And do you know by what standards participation in a Cabinet committee or subcommittee is established?
Normally the criterion would be that you have a material interest in the matter under discussion or task that is given to, for example, an IMC, an interministerial committee.
Thank you. If we may then move on to just mention in passing the litigation that you became aware of. That application is complex and to an extent quite technical, and it's not necessary to go into it at this stage. But you became aware of two things whilst you were Minister of COGTA. Firstly, the litigation that ultimately succeeded at the hands of the applicants to set aside certain memoranda and certain basic decisions, the reasons we can leave for another occasion. And then the intergovernmental agreement with the Russian Federation. Do you have any comment there? And maybe this is the time to deal with the sequencing of the involvement of the Russian Federation and then other countries as well.
Well, once it became known publicly that there was this agreement, Chair, with the Russian Federation. Then it appeared that the Department of Energy and the minister concerned had similar agreements entered into with a range of other countries that have the capacity to supply nuclear power stations.
The agreements, I'm sorry, the agreements being a reference, or the reference to agreements being a reference to memoranda of understanding.
I'm just using my language.
Yes.
But
Okay.
yeah, let's use the word agreement. Sorry about that.
I just want to make
Yes.
sure when one reads the transcript, one knows if it's a reference to the same thing.
Yeah.
Okay,
So
thank you.
yeah, I'm not sure what they officially were titled.
Yeah.
But I think here we refer to intergovernmental agreements, so that's what we're talking about. And there was also the issue about whether within the kind of procurement legislation we have, government-to-government procurement was actually permitted or not permitted, or what process would be required, as opposed to government procuring from a private sector. So that was one of the confounding factors that needed to be clarified as well.
At the stage, your evidence is that in relation to the nuclear deal, here at paragraph 49, had any final cabinet decision been made to proceed with a particular class of procurement?
Not at that time, as I remember it.
And at that stage, what was the attitude of National Treasury? You deal with that in paragraph 48.
That, as I've said on several occasions now, Chair, that there had to be a proper evaluation of the costs. Now, let me give you an illustration. Often in many of the, let's call it international procurement agreements that entities or government enters into, the exchange rate is an important factor. So you could start a whole calculation based on an exchange rate of, say, 8 rands to the dollar. But by the time you conclude the agreement or move ahead in any firm sense, the rand to the dollar exchange rate could be 12 rands to the dollar. That means your entire cost structure is miscalculated. And sometimes you have deliberate misstatement of the rand-dollar exchange rate, and that then begins to impact on all of the other numbers. And then you don't, that is why reference is made to the true cost. So you need to check all of the assumptions that underlie. So in some of the transactions, for example, the estimated cost of oil would be a factor. Remember, at some stage, a few years ago, and that's not too long in the past, we thought oil would fall to $10 a barrel. Today, it's somewhere between $60 and $70 to the barrel. It was only 3 or 4 weeks ago when it was heading towards $80 a barrel. Now, if oil is a key factor in this, say, a particular transaction, and you calculate it at $25 to the barrel, and again, your whole calculation goes completely off track. So that I'm just trying to illustrate the importance of assumptions and costs arrived at, and what might actually be the true cost if the assumptions are based correctly.
May we then proceed to your evidence in relation to the Petro SA engine Petronas acquisition or proposed acquisition? It's at paragraph 50 of the statement.
Yes. So this was a transaction that came to the Treasury and my attention I can't remember exactly how, but it involved, Chair, the assets of Petronas in South Africa, which is what we know as Engine. And they are the retail fuel stations that we are familiar with, but there were other businesses like the lubricant business and others that were attached to the assets that Petronas had in South Africa. And it appeared that there were discussions between Petro SA, which accounts to the Department of Energy, and Engine to purchase the assets, in particular the fuel stations of Engen, which had quite a footprint, both in South Africa and I believe in other parts of Southern Africa as well.
Minister, there are a number of issues of concern that you've raised under this head. The first was the apparent difference between the market value of the business to be purchased and the asking price. The second was the request to give guarantees, and the third, the request to Treasury to give guarantees, and the third was that due diligence and the performance of the due diligence became an issue. Would you care to deal with those issues?
And this is pursuant, Chair, on paragraph 53 of the statement. So Mr. Pretorius is right. The asking price shifted somewhere between 17 billion and eventually 18.68 billion rands for these assets. And in various interactions with people familiar with the industry, including a leading black business person that I had interactions with, and I thought this could be a very interesting black empowerment transaction, entering this market space with this kind of infrastructure and footprint. He said, I won't touch it. I said, why? And he said, no, the market price is between 12 and 14 billion. So here's 12 to 14 billion, and there's 18.68 billion. So here's this difference between asking price, so to speak, and what appeared to be market value. So that's the first concern, as Mr. Pretorius points out. The second is that, as when you go through the documentation, there was some agreement struck, and again, Mr. Martins is in the best position to give you some of the details. We had a more distant view. But the idea was that Petro SA would enter into some kind of partnership with Sonangol, which is the Angolan oil company, and that Sonangol will provide some of the cash or other financial instruments that are actually necessary for this transaction. Now, for that to happen, in most instances, nobody's going to put in this amount of cash or part thereof if there isn't what is commercially known as due diligence. Some of the lawyers here might be familiar with that. That is undertaken. I think in the Sonangol letter that you see in the annexures at Annex 11, they also talk about, firstly, one of the top 20 banks in the world, not 20 banks in Africa, should be involved in this transaction. But they also make reference to the necessity for a due diligence. And for some reason, what was being asked of the South African side of the transaction is to accept the due diligence that Petronas had undertaken. And you'll find that in the documentation as well. But I think normal commercial practice would be, if I'm going to invest, I want my own investment advisors and so on to undertake the due diligence. So there was a gap here which needs to be explained. The third was a request from Minister Martins to the Treasury to provide a guarantee for the sum of 9.5 billion rands.
Now, Minister, there may be some confusion or lack of understanding as to how that 9.5 billion guarantee request relates to the 18 billion or the 12 to 14 billion. If you would turn to page 139, your legal team did some work overnight on the calculations. 139 of the supplementary bundle.
So this is some arithmetic that would help everyone. So the value claimed by the Energy Department, 18.68 billion, as I indicated. True market value between 12 and 14 billion. Sonangol gets...
Perhaps we just better introduce Sonangol into the evidence. They were to be a partner in the deal.
I indicated that.
Yes.
And they get 49%, and they indicate in their letter, Chair, that they'll take 49% now, but eventually sell off different percentages in the marketplace and possibly to black empowerment partners over a period of time. Petronas gets 51%. Together, they pay 80% of the purchase price, which amounts to 14.4. And the guarantee, as Mr. Pretorius indicates, of 9.5 is to cover Petronas, which is required to find 4.6 billion.
5.6.
5.6, I beg your pardon. And Sonangol 5.4, although that doesn't add up to 9.5. But it's to actually look at the lenders who would come up with 4.1 billion. So it's that gives you your 9.5. In the event, and there was, my former DG informs me, or reminds me, that whilst we were concluding the year-end revenue numbers at the Revenue Service, which was a tradition at the time, which is indicated in paragraph 54, that there was a telephone call from the President that I took, who was inquiring about whether we had concluded the provision of the guarantee, and I want to come back to that in a moment. There was also a meeting between myself and Minister Martins on the 1st of April, which is indicated in 54.2. That's the first inquiry, rather. And 54.4 indicates the 1st of April meeting with Mr. Martins, whereafter Treasury does give a letter of guarantee, but which is conditional upon a number of factors being met, including the completion of a due diligence exercise. Finally, of course, this deal fell through at the end of the day. The issue of guarantees being provided by the Treasury might pop up a few times. So I thought it might be useful to explain how this works. In the Treasury over the years, what has been set up is what is called a Fiscal Liabilities Committee. It's made up of a few senior officials within the Treasury who, if you like, act as an objective team. And if another official or an entity wants to have a guarantee of, say, in this instance, 9.5 billion rands, you provide the paperwork. If need be, you make yourself available to answer questions to them, and then they decide, having a look at both the credibility of the business case that has been provided and the fiscal environment at that point in time, whether and the viability of what is being proposed. They decide whether a guarantee will be issued or not. Now, guarantees constitute, in both legal and financial terms, contingent liabilities. So I can give you a guarantee that Paul Pretorius will pay you 2 million rands tomorrow, but if he doesn't, then I have to pay it. So I haven't paid it yet, so it's contingent. Some ratings agencies, when you start approaching debt to GDP over 50%, then begin to look at not only the actual debt that you are committed to, but also add the contingent element to see what level of risk do you constitute as a sovereign, as a country. And that's why there's a lot of importance placed on process, an objective and viable business case being provided, and then the FLC, the Financial Liability Committee, makes a recommendation to the Director General, and that finally gets to the Minister as well.
And looking at those contingencies by those rating agencies would be quite legitimate, because what if the risk materializes or not?
That's the point.
Yeah.
So that's the point, Chair. So, for example, Eskom has a guarantee standing at the moment of 350 billion rands, of which I'll forget the immediate number, but it's probably used up between 220 and 240 billion rands of that guarantee. In other words, it's actually borrowed against the guarantee. And its total debt is 400 billion rands. So there's some non-guaranteed debt and there's some guaranteed debt. In some instances, lenders also have, I hope I get the technical term right, but a cross-default clause, which means that if one of your state entities doesn't pay up on the due date, it could have a domino effect on others as well. So not only will they ask you to pay what that entity was supposed to pay, 5 billion rands, for example, a cross-default clause will involve the others as well. And then you place the whole country at risk. So one of the things that the Treasury applies its mind to, and government as a whole, is not to ever get into that position where there's a default on debt by its entities. But guarantees are not automatic. It doesn't mean if you request one, you get one. And that contestation and that pushback from the Treasury is very useful as part of the check and balance process within government itself.
Thanks.
The exchange between yourself and the former president, and between yourself and Mr. Martins on these topics at this time are dealt with in your evidence at paragraph 54.2 to 54.4. Is there anything you wish to add?
No, the only points to emphasize is that there was the request, there was the deficiency in relation to the price differential, there was the issue of due diligence being allowed and why the hesitancy by some parties to entertain what is normal commercial practice, and again, that an unqualified guarantee wasn't going to be forthcoming, because that would be irresponsible of the Treasury to do, and so you have the qualified guarantee. And I suppose in some instances people would be upset because they don't understand or appreciate or have regard for the kind of concerns, as Minister Manuel pointed out in his document, the guardianship role, if you like, that the Treasury is assigned over the fiscus, and the kind of check and balance role that that actually has to play on behalf of government.
As I understand your evidence, Minister Gordhan, it was Treasury's insistence that there be a due diligence and an agreement to issue a guarantee subject to conditions. I'll get back to your comment in paragraph 54.5 in a moment, but would you go to page 110, please? Of the bundle in front of you in which your statement appears. It's 110, it's bundle M1A. It's the bundle in which the statement appears. It's the first bundle at page 110.
What page must I look at?
110.
110. Yes, Mr. Petronas.
What document is that? You'll see on page 111 it appears to have been signed by yourself. Is this the guarantee?
That's a fraudulent signature. No, I'm joking. No, that is signed by myself. Mr. Chair, and that's the guarantee document that I referred to earlier on. And the first paragraph after number 6, in the third line, makes reference to a comprehensive due diligence that I indicated earlier on as well.
So it appears from this document that a guarantee of 9.5 billion rand was afforded or issued, subject to the conditions in paragraphs 1 to 6, but also subject to a comprehensive due diligence being undertaken.
That's right.
Now, the origins of this document appear to be highlighted in your evidence at paragraph 54.4, arising out of a conversation you had with Mr. Martins. Would you relate the contents of that conversation or that exchange, if it was more than a conversation, to the Chair, please?
Well, what 54.4 indicates, Chair, is that in that conversation, pursuant on the call from Mr. Zuma, I indicated to Mr. Martins on the 1st of April that it's quite important to have A, further information, B, the detailed due diligence on the transaction before any guarantee could be provided. A due diligence is, as we point out in the paragraph, a comprehensive appraisal of a business undertaken by a prospective buyer, especially to establish the value of its assets and liabilities, and in order to evaluate its future commercial potential. Sonangol's participation in the transaction, as I indicated earlier, was conditional on the successful completion of a due diligence exercise. I think if one had to explain it for the public in simple terms, it's like buying a second-hand car without examining it, right? And somebody says, you know, if you buy a new one, it's going to cost you 500,000. I'm offering you this for 400,000, but you don't know what's below the bonnet. So due diligence could well be, if you're a good mechanic, you can check the car yourself or ask a trader or some car shop to check it for you, or the AA, and once you're satisfied that it's worth 400,000 rands, then you'll be willing to pay the 400,000 rands. So I think we will all understand that we wouldn't part with 400,000 rands without understanding what we're buying. The same applies here, except there's one additional factor, the commercial viability. And essentially what that means, I imagine, is that am I buying something that's going to last for a long time and is going to make me money because I'm investing in it at the end of the day. And that's a simple proposition that in a day-to-day exercise each one of us might have to encounter.
You then make a comment in paragraph 54.5 regarding a possible view that existed that the due diligence or a due diligence should not be conducted. Was that factually correct? Was there resistance to a due diligence?
That's what it appeared like from the various interactions that I had, yes. Otherwise, if you wanted Sonangol as a serious partner, and they make explicit in their letter they want to conduct a due diligence before they part, before firstly they agree to a partnership, and secondly before they part with any money. And if you are serious about the partnership, then I imagine, Chair, that you agree to a due diligence exercise and wait for the 2-week or 3-week period for that exercise to be completed.
In other words, if you are selling somebody a second-hand car and they want to bring a mechanic to have a look at it, if you resist that, you may be chasing them away.
Yeah.
If I may ask you to go back, a query has been raised by the legal team in relation to page 110 of the bundle, the first bundle, M1A.
You have got to be consistent now with what you call them.
Yes.
Which one now?
I'm sorry, did I say M? I meant N, firstly, N1A.
The one
The
with the
statement.
statement.
The first one.
Okay, what page must we look at?
110. We need to go back
Same
to page
letter.
110.
Oh, okay.
We've just been there. I'm asked to ask you to explain, if you would, Minister, how Pembani Group Pty Limited came to be involved.
It appeared that they were partners with Engine in the Petronas stable.
Right. And there was to be private equity as part of the deal, as I
Yeah,
understand.
I can't remember the full details of all of that.
How did you conclude, Minister, that there was indeed, and it may be my fault because I put words in your mouth, that there was a resistance to a due diligence? What led you to conclude that this idea of a detailed due diligence was not well received?
Well, firstly, as I said earlier on, Chair, in the conversations that took place around this transaction. Secondly, as I also indicated a moment ago, you are saying, or Petro SA is saying, Sonangol is our 49% partner. That's a big stake, that's not 5%. And if Sonangol says, I want a due diligence exercise to be done, amongst other conditions it puts in its letter, by the way, like the top 20 banks in the world being involved in this transaction, then if you're serious about the deal, you say, yes, go ahead, I'll wait. Now that wait could either be from the Petronas side, because there was some deadline agreed upon between Mr. Martins and themselves, about 31st of March being a critical date. And so you can see phone calls on the 31st, meetings on the 1st, and so on. So those are the two things, or two elements that lead one to the conclusion. And again, when Mr. Fuzile appears before you, because he dealt with the technical part of the details, together with other officials, he could elaborate on this.
But there's no suggestions that Mr. Martins resisted the performance of a due diligence, is there?
I can't say that with any conviction, no. But I imagine that if you're overseeing this transaction and you understand the importance of the partnership and the kind of contribution that Sonangol is going to make, and that due diligence exercises are part of these big commercial transactions, then you provide the space for it.
Right. Can we just then conclude this chapter by telling the Chair what happened ultimately to the potential transaction?
In paragraph 56, I indicate that the transaction did not proceed because Petronas withdrew from the deal after Petro SA failed to fulfill the financing conditions and a due diligence exercise was not performed. As a result, I understand that then the last sentence is in relation to the post-2014 process. As a result, I understand that the guarantee was withdrawn by my successor, Mr. Nene, on or about the 9th of March 2015. And at page 113, I think, yes, of the, now let me learn, bundle N1.
N1A.
N1A, I beg your pardon. I got something wrong. Mr. Nene's withdrawal of the guarantee letter appears.
Was it ever revealed what the reason was for there to be such a big gap between the market value and the asking price, or that never got revealed?
No, there was no explanation, and that's why we put this before the Commission, that this is a potential, that what could have turned out to be an area of malfeasance.
Minister, you were the Minister of Finance in May 2014, and then shortly after that, you were asked to occupy a different ministry. You deal with that under the heading My Appointment to COGTA. Would you deal with that, please?
Actually, he was Minister of one department for part of May 2014 and Minister of another department for the latter part of May 2014.
Yes.
Right.
As you know, in the transition process after an election, you remain a minister until the next minister is appointed. So, yes, our term of office as Minister of Finance extends into May 2014, and then, as I indicate in paragraph 57, on the evening of the 24th of May, it was more like the morning of the 25th of May, because these processes that I'm describing can sometimes last until 6 o'clock or 7 o'clock the following morning. After the inauguration ceremony, I received a message to meet with the former president, and as is the tradition in making appointments to cabinet following an election, I was then informed by the former president of my appointment as minister responsible for COGTA.
And your position as Minister of Finance was taken up by Mr. Nene at that stage?
That's right.
Until then, he had been your deputy.
Yes.
Then at paragraph 60...
Before that, Mr. Pretorius, in paragraph 58, and you say there was speculation in political and media circles that you'd be moved from the post of Minister of Finance. Was there an indication as to who would follow or not really? Who would succeed you?
There might have been that speculation as well. In any pre- and post-election process, that's the sport that the first two rows play, you see.
Was there, well, let me ask you, Minister, was there any especially informed speculation in regard to your potential removal?
No, I can't recollect any. There might well have been.
And may we then go to paragraph 60 and deal with the circumstances that existed, which you have highlighted in your statement at page 26 and following, at the time of the dismissal of Minister Nene, as he then was. And you deal first with Denel Asia. As I understand it, you don't claim to know the exact reasons for the removal, but you suggest to the Commission that there may be circumstances relevant to that about which you can testify. Am I correct?
Yeah, this is anecdotal material, if you like, in relation to Minister Nene. I think it's well known now, and I think in his own testimony before you, he indicated that he refused to sign a particular document in the Russian Federation. And in the period some weeks before, not even weeks, perhaps even 2 months before the 9th of December, there were very odd occurrences within Cabinet itself, and where, maybe in the public domain, I can't recall now, where the Treasury came under constant attack and criticism. And some had the very simplistic view, Chair, that as the Treasurer, your job is just to find the money. In other words, somebody decides how much is needed, go and find the money. because this is different from give back the money. But in the context of what I've explained earlier on, in relation to managing the fiscus, is not as simple as that. So, yeah, one can't, obviously there was something that needed to happen. In Minister Nene's term, I think he might have made reference to issues around SAA, because post the 2014 elections, SAA was transferred to the Treasury from the Department of Public Enterprises as well. And we'll come to that as well in the statement. So he had to deal with some contentious issues there also. And in that sense, I suppose he began to share our collective reputation as finance ministers for being stubborn and not just conceding to whatever might be needed at a particular point in time without raising potentially difficult questions. So that's the issue around Minister Nene. The rest of 61 then deals with the creation of an entity called Denel Asia. I indicated to you previously and earlier on that no government department or entity can create another commercial company without prior consent, both from the relevant executive authority that that entity or department falls under, and further notification and approval in terms of Section 54 and 51 of the PFMA. And this is one of those instances. And there's this so-called pre-notification exercise that was engaged in by Denel. And we today know from the Gupta emails and so on that the Denel board was captured, inverted commas, so were some of the managers at a certain point in time, and part of the cleaning up process has involved some of those elements. But on the 30th of October 2015, a so-called pre-notification was received from Denel by the Director General of the National Treasury. So again, Mr. Fuzile, when he appears before you, can give you more detail into that. And what that pre-notification indicated is that a new structure between, as a result of a partnership agreement between VR Laser, a Gupta-affiliated entity, and Denel itself is going to be created, called Denel Asia. And the idea was that, as we indicate in 62, that, and I'll read the sentence from this paragraph, the joint venture was contemplated purportedly to exploit Denel's intellectual property and proprietary information in India. The joint venture was to be known as Denel Asia. Now, Denel chairperson, over the years, has developed quite remarkable technical capability and a lot of innovation capability. So this intellectual property is the property of the state. So it's our collective property, so to speak. And it's much sought after then and now. And in fact, there's lots of funny, if I may use that terminology, rumors going around about how that intellectual property might be escaping our country at this point in time. But we'll come back to that at a later stage. So what 62 indicates, Chair, is that VR Laser Asia is a company owned by Mr. Salim Isa. I made reference to him earlier on. He is, I think, in self-declared exile. Is a Gupta, well-known Gupta associate, and he would be one of the brokers, as we described under our previous hypothesis. And as its sole shareholder, and which has a relationship with VR Laser RSA, that's South Africa, owned by Mr. Duduzane Zuma and Rajesh Gupta. The joint venture was contemplated, as I said, to exploit Denel's intellectual property and proprietary information. So they don't even say that they are going to act as an agent to sell the products of Denel. It's to exploit the intellectual property. So they were going to actually sell intellectual property. That is, in fact, the valued asset of a state, it would appear.
The allegations that were in the public domain, you've included in the bundle N1A at pages 118 to 119. I don't necessarily want us or need us to go there, but simply to ask you, as I've been asked to ask you, you said in your evidence that the Denel board at that stage had been captured. On the basis of what do you conclude that?
Well, if you look at this page 118 and subsequent reports, which cover the investigative journalism, an excellent one at that as well, undertaken by Amabongane and Scorpio Chair, you will see how different personalities within the Denel enterprise were regular visitors to Dubai, had their household bills paid for in terms of the emails that were disclosed, and featured in different ways, as this article also indicates, in relation to the creation of Denel Asia. And what followed, in particular in terms of the behavior of the then chair of the Denel board, Mr. Mancha, I think justifies a conclusion that there was serious collaboration with, let's call it the Gupta enterprise, in this process.
Your conclusions then, were they drawn on the analysis of Amambongani, or have you had sight of the emails themselves?
Well, the rest of the statement covers the various stages of this conflagration that we had between the Treasury and Mr. Mancha. So perhaps if I take you through that, some of the answers to the question, Chair, might appear more clear.
Thank you, if you would.
So at 64, Chair, we indicate that according to media reports on the information contained in the Gupta leaks, and your own investigators, Chair, who have access to the emails can confirm this as well for you. One day after Denel submitted his PFMA application to National Treasury on the 30th of October, the Denel chair, Mr. Mancha, forwarded the confidential document. This is a confidential government document to Mr. Ashu Chawla, a senior Gupta executive and CEO of Sahara Computers, a company owned by the Gupta family. At 65, we indicate that on or about the 23rd of November 2015, Ms. Brown, the then Minister of Public Enterprises, provisionally approved the initiative and set out various issues that needed to be covered in the formal PFMA application. As the pre-notification was not a formal PFMA process, there was no requirement for the Treasury to respond, nor did the Treasury usually respond to such pre-notifications. At 66, emails contained in and reported on by the media following the Gupta leaks show that on 7 December 2015, interestingly it's 2 days before Mr. Nene's dismissal, Mr. Chawla emailed a copy of Ms. Brown's in-principle approval and a briefing document directly to the personal assistant of Mr. Nene. 67, before Mr. Nene was removed as finance minister, no formal PFMA application had been submitted seeking his approval.
which
of the
according to
establishment.
evidence is a requirement of the law.
That's in terms of the requirement of the law. Of the establishment of Denel Asia, therefore, Mr. Nene had not approved the joint venture. Now, here's the coincidence, if you can call it that. 68, however, it's not even days later, but a day later, after Mr. Nene was removed, on the 10th of December 2015, when Mr. Van Rooyen was appointed as finance minister. That's on the 10th of December 2015. In terms of 69, by 11 December 2015, the formal PFMA application seeking approval for the establishment of Denel Asia was submitted, addressed to the newly installed minister. So this is just a day after his installation. Mr. Van Rooyen did not have the opportunity to approve the joint venture prior to him being removed as finance minister. So if you remember, I said that he had just 2 working days, I think, in office.
Just before you proceed, again, I need to ask you, we know that at the time Mr. Mancha, Daniel Mancha, was the Denel chair. Do you recall from your own memory any other members of the Denel board at that time?
Several of them had resigned over a period. By the time we took over that responsibility earlier this year, in fact, 2 board members remained, and a completely new board was then appointed. But in my other capacity as member of the Public Enterprises Committee chair, I did have occasion to be in a meeting of the committee when Denel came along to present its, I think its financials, and had some interactions with both the senior management of Denel and Mr. Mancha himself on that occasion. May I continue?
What legal advice, as you refer to in paragraph 70, did you obtain, or did National Treasury obtain, in regard to the necessity for approval?
This the officials would have done.
This matter.
I'm sorry.
Yes.
I'm not sure whether, when you asked whether you could continue, you wanted to continue in terms of the meeting of the portfolio committee?
No, sorry.
Or you wanted to continue
Yes.
here?
Yes.
Oh, okay, thank you.
All right, you refer to legal advice in paragraph 70, and the question is then, what was the content of that advice?
Well,
may I just ask, was this received by you in National Treasury once you had become minister?
That's right. Yes, because the application was now on my desk, so to speak, having been appointed to that position on the 13th of December, 2015. And as we indicate 5 lines, I think, down into paragraph 70, that the legal advice that was given was that prior approval was required for the formal establishment of Denel Asia.
And
This
that was
information was communicated both verbally and in writing on several occasions to Denel, as well as to the then Minister of Public Enterprises, Ms. Brown.
And that approval was required in terms of the several sections of the Public Finance Management Act, and the approval was required of the Minister of Finance.
That's correct.
You mentioned the sections in paragraph 70. Then would you continue with the fallout, as it may be termed, that occurred?
So at paragraph 71, Chair, we make reference to the following: that extraordinarily belligerent attacks were made on me personally and the National Treasury more broadly by Mr. Mancha as chairperson of the Denel board. He demanded that I retract in writing to the Denel board comments and statements I had made regarding the lawfulness and desirability of the joint venture and apologize to the Denel board. He also wanted me to acknowledge that National Treasury had failed to discharge its duties in a diligent and responsible manner, even though the reverse was actually the case. Furthermore,
just before you go on, these exchanges between yourself and Mr. Mancha, were they personal exchanges? Were they written exchanges?
They were
exchanges
media
between
exchanges.
legal representatives?
Media exchanges.
Media exchanges.
I emphasized later in 71 that it is unheard of for the chairperson of a state-owned company to attack a Minister of Finance in public, and for the Minister of Public Enterprises responsible for that SOC to take no steps to rein in such attacks to the best of my knowledge. You also see at page 148 of N1A, I think I got it right this time.
Yes. If you would go there, please. That's a
National
Treasury statement.
Media statement.
Issued by Treasury,
Yes,
by National Treasury.
that's right.
Mr. Petronas?
Would you read that onto the record, please?
The whole statement.
Insofar as you
Did
feel
you want him to
appropriate,
read it into the record, or you wanted him to read it quietly?
No, onto the record, please. Well, perhaps we should just deal with the first paragraph. If you could read the first paragraph onto the record.
All right. The National Treasury has noted media reports that Denel may have entered into a joint venture to form a company that will operate from a jurisdiction in Asia. So this company, Chair, is actually registered in Hong Kong. And it's a formidable task to deregister the company because it had Mr. Issa as a 50% partner and Denel as a 50% partner, I think, if I get the numbers right. And to disestablish it in Hong Kong requires both parties to agree. And we can't find the mysterious Mr. Issa. So the current Denel board is having to enter into all sorts of legal gymnastics to ensure that the company is deregistered in Hong Kong, just as an update. So the paragraph further says, National Treasury is currently engaging directly with Denel on the matter. The statement seeks to clarify facts relating to the transaction. But if I may, Chair, the next paragraph indicates what the President said on the 11th of December 2015. That's President Zuma.
2015.
2015. There is no state-owned entity that can dictate to government how it should be assisted. And it goes on. And then the third paragraph, the board of a public entity commits an act of financial misconduct where it willfully or negligently fails to comply with the PFMA. And then it says that the Treasury regulation specified that such allegations must be investigated by the executive authority, and if confirmed, appropriate disciplinary proceedings must be initiated.
Can we pause there, Minister? The statement then goes on to quote sections of the
54
Public Finance Management Act, which you have referred to. We needn't go there, but if you would go over the page, please. And just read onto the record the contents of the statement on the second page.
In terms of the conditions attached to the 1.85 billion in guarantees that have been provided by government to Denel, any significant transactions that Denel enters into requires the approval of both the Minister of Finance and the Minister of Public Enterprises. So these are the conditionalities that I referred to earlier, Chair, that a company guarantees. Section 54.3 allows for an entity to assume that approval has been given if it receives no response from the executive authority within 30 days or within a longer period as may be agreed to between itself and the executive authority.
That clause was subject to litigation, which we will deal with perhaps tomorrow, Minister.
Yeah,
If you
and
could just deal with the next paragraph.
again, the litigation took place after my dismissal. So again, Mr. Fuzile and his affidavit is very material here. But the interesting point, just for the public to understand as well, you submit an application on the 10th of December, and the Christmas break and the New Year break is upon us. The 30-day period ends approximately on the 9th or 10th of January, when most people are still on leave. Common sense, if not anything else, dictates that you wait until people are back at work, you inquire whether the application has been attended to, and if there's any further information required, then you supply the necessary information. Now, Mr. Fuzile will describe other meetings that took place amongst the officials between Denel and the National Treasury, if you ask him to, and that showed that that's the kind of conversation that needed to actually take place, rather than the assumption that once the 30-day period is over, that's the end of the story, and you can go ahead and do what you like. So one must ask the question, why the urgency? If you waited another 3 weeks or 4 weeks, what would not have happened? And what would the cost have been to whom? And of course, the flip side of that coin is who benefits by all of this, by rushing it through. So people who are involved in this, Chair, might want to then enlighten you on those questions when they appear before you.
Just to summarize then, Minister, in the third paragraph on page 149, it's recorded by Treasury that Denel had submitted its application on 10 December 2015, but prior to that application being submitted, National Treasury had outlined the information that would be required comprehensively to assess the application, that the Minister of Finance was still considering the application, and that further information had been requested from Denel. And then finally, the last 3 lines indicate that on the 13th of April 2016, that is the date of the media statement made on behalf of Treasury, the application was still under consideration and no decision had yet been made.
And if I may add, Chair, Mr. Pretorius, the first 3 lines of the last paragraph is also very material. More significantly, Denel is also required to comply with Section 51(1)(g), which is unequivocal in its requirement that the Board of Denel obtain approval before establishing a company.
Thank you. If I may just, before the adjournment, just relay one more question to you from the legal team. Do you know at all, Minister, why Salim Issa, who you've referred to earlier, left South Africa? Do you have any knowledge?
Will you just repeat the question? I didn't hear. Why, blah, 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 blah?
I'm not sure that it's a fair question, whether your intelligence stretches that far.
Chair, with respect.
It's a
I don't know Mr. Salim Issa. I have not met Mr. Salim Issa. He's not a drinking partner, and I only drink water either. So I think some of his family might be around, and you might want to call them and ask them the question, where's your family member? And why is he ducking the authorities in South Africa?
We'll leave it there. Chair, is this a convenient time?
Okay, the time is 4 o'clock. We'll take the adjournment, and it is the understanding that you are still available tomorrow to continue.
At your service, sir.
Thank you very much. We'll adjourn until 10 o'clock tomorrow. Adjourn.
All right, so that's the first day of the testimony of the Public Enterprises Minister, Pravin Gordhan, who's held